Hello. Don't know why you've signed yourself up for this. It's not the most invigorating topic, and the one on track one sounds much better, but you're here, so we'll go for it. I'll just introduce myself. My name's George. I'm a student at Napier, so I've come from the lovely city of Edinburgh today. I'm disabled, so I'm canoeer. You put the two together, you get paracaidist. And in terms of computing and cybersecurity, I like data law, I like computing law, I like the boring stuff, really. It's more of an academic presentation compared to the other stuff you've done. So I've actually sat down, I've done the research, I've got sources, I've got citations. I was lazy, so they're all at the end. But I can tell you which bit's what. And there's going to be a lot of talk about some of the freedom of information requests I've done. If you want those, there are a couple that I can't give out because they're either being contested with the ICO at the moment, or they contain data and information I can't reproduce. But I can share other ones. I'll put my contact details at the end and people can get in touch if they want them. So we're going to go over data protection history, the Data Protection Act 1998. So we're going to go all the way back before I was born. Data Protection Act 2018. You can see a pattern here. UK GDPR and freedom of information, and my freedom of information requests, and conclusion as well. Before we start, I want you to think from the title you think back to these acts on the screen here, and I want you to think about whether you think they're still fit for purpose. It doesn't matter if you don't know much, it doesn't matter if you know everything about them, but just think, are they still fit for purpose in any way that you believe? Just in your head, come to that conclusion, and then hopefully I might change your mind, I might reinforce it, or I might completely confuse you, and hopefully it'll be one of those three. Just do some definitions for people who don't know. I'll let you read them. I don't really want to read off the screen, but just 3 acts basically to go through them and stuff. So obviously we've got the Data Protection Act up there, the UK GDPR, which lots of people don't know about. That was a very sneaky post-Brexit law. It essentially takes the EU elements of the Data Protection Act and removes them and puts them into a UK context. That's all it does. It doesn't really do that much. And then Freedom of Information Act, that should be 2000. Don't know why I put 2018. That's my mistake. It is 2000. And Scotland has its own Freedom of Information Act as well. So we'll go over a bit of history of data protection in the UK. So we start off with the European Declaration of Human Rights. That is a UN thing, but it was adopted by Europe as well. That's 1948. That gives you the right to privacy. It's why that's important. So we have an inherent right to privacy. That's where we get the idea of a privacy notice from, privacy policy. Obviously that's encoded in law, but the idea of that right to privacy, that right to having your information secure, it's a human right. So it's not something that's a legal right. It's a human right. So if people are breaking that, then we've got a bit of a problem with them. Then there was the Data Protection Convention. Almost 40 years afterwards. We're very slow in computing to catch up with stuff sometimes. But that was the first Data Protection Convention. Then there was the UK Data Protection Act from 1984. It was an EU directive. Then you ended up with the next EU directive, and you can see the pattern. We get a Data Protection Act out of it. We get the UK Freedom of Information Act, which caused, if anybody knows, the MP expenses scandal, because we got to know everything about what they were spending their money on. And then we got another directive and another UK law. And you can see the pattern here. Ended up with the Data Protection Act. And then we left the EU. That's a very important thing to note, and we ended up with UK GDPR. So nice and simple how we got there. Pretty easy stuff. In terms of Data Protection Act 1998, introduced 8 key principles. So the first one, it said that data must be processed fairly and lawfully. And you can see if you've read the Data Protection Act 2018, you can see the comparison, you can see the differences. I haven't actually got these principles for 2018 because it's not really relevant to what I want to talk about. But it's looking at what changed from 1998 and moving on from that. So there's the specific and lawful purpose. There's about things not being excessive. So, they don't need your middle name for them to take, like a bank payment, for example. They only need your first and last name. Or, they're signing you up to a mailing list. They only really need your first name. They don't need your last name. They don't need any of that. So that's what they're talking about with excessive data. They're also talking about things like, they're sending you an email. They don't need your address. They don't need your postcode. They don't need things like that. The data must be accurate. So you have a right, or you still do because he's carried across, but you did, and you still do. You have this right for your data to be accurate. There was a very interesting case somewhere else in the EU, I can't quite remember where someone had signed up to Tinder, and they were over the age of 18, but they'd accidentally put their date of birth in under 18, and they successfully took Tinder to court over the fact that they wouldn't change their data and this was pre-2018, because that data must be accurate. And so even if you've given misaccurate data, you have a right for it to be amended, and then not kept longer than necessary, processed in accordance, appropriate measures, and that protected by appropriate measures. That's very not very specific. And if anybody was in track 2 at 11 o'clock with Richard Hollis, fantastic talk, talking about how the cybersecurity industry is broken. And that he kind of touched on that a little bit, about the fact they talk about appropriate measures, but there's no standards for it. And there's no kind of regulation of that. And we'll talk about that in a second as well. And you can't transfer data outside of Europe. And if you do, you needed a data passport, essentially. So what works out of that? It served as a reference model. So it harmonized data protection principles, and to a certain extent, it enabled an internal market for personal data. So it allowed people they weren't against people selling data. The EU appreciated that people do that. It's a market and exists. But it created this market of being able to sell personal data within the EU. And so you had these big companies that their sole job was to just sell data within the EU. So they would take American data, or they take EU data and sell it the other side, because they had these special passports. It harmonized the principles. So it essentially it was a principle-based framework, and so in turn it permits flexibility. It was also technology neutral, so it didn't depend what you were using. It could be post, or it could be like you're sending a letter to somebody, and you have to keep you've got this big address book, and it's physical paper address book. You still have to keep that under the Data Protection Act, compared to you might have an Excel sheet or a database instead. And it approved awareness as well of data protection concerns within Europe and within the UK specifically. But what didn't work? So there was a Supreme Court case of Lloyd. Lloyd is the name of the person who brought the class action lawsuit versus Google. I'm very going to briefly touch on this. So the case was under the Data Protection Act 1998, because the incident occurred in 2015. And essentially Google on iOS devices on Safari had a third-party cookie that they forced onto Safari and Chrome, and essentially you had no option to get rid of it, and it was harvesting data, and it was giving that data to Google without your permission. It never asked for that permission. It never told you it was doing it, and it wasn't until some clever people found out that they got in trouble. And essentially they got fined, but people were annoyed about the fact that their data was used and misused, and they wanted some justice. And unfortunately, in the Data Protection Act 1998, and still in the Data Protection Act 2018, there's no value to data. But there is value to data, because otherwise companies wouldn't want it. They wouldn't want to sell it. So essentially it meant that it made it impossible to quantify the cost of personal data breaches. So there was never a payout for victims. The link between personal data and privacy issues, it was really unclear. That's essentially it. There was no kind of link between the two. So there was no kind of insinuation that there was a difference between people's personal data and the risks that would come with it. They were just kind of seen as two things. They weren't seen as something that could be linked. There was limited transparency. So the measures aimed at providing transparency of the processing, they were inconsistent and they're ineffective. And this is from a report to the Information Commissioner's Office. So these aren't my opinions. These are academics and legal experts' opinions that I've taken from readings that I've done. There were rules on data exports, and they were really outdated. So they were written in 1998. That's when the law was enacted, but they were written as in they were in the 1950s, 1960s, is what the report said. And it just didn't work, is the best way to put it. The tools that you had for data export, they were clunky and cumbersome. You were given them by the EU. So within the directive, there were this list of tools that you could use, and they were named. And that's a very odd thing. And they were old, because these companies knew that you didn't have to, what's the word I'm looking for? You couldn't use something else. So if there's 20 tools, you're going to use one of the 20. And some countries are allowed to use some tools and some were not allowed to use others because of the way they'd interpreted into their Data Protection Act. The Data Protection Authorities, as they've been known, instead of information commissioners as they're now known, they didn't have like strict accountability and enforcement. It was kind of vague. And the EU, again, it's a directive. It was guidance. It wasn't law. So it meant that the UK could interpret it completely differently. And actually then it wouldn't be consistent, wouldn't line up with Europe. And then you've also got to look at the definition of entities. It was simplistic and static. There was no dynamic kind of to it. And so now they've broken it down into 3, and we'll go through those in a little bit. But there was no definition of them. So you didn't know who was a data controller. You didn't know who was the processor. You didn't actually know whether you were a data subject or not, or whether actually you were a middleman. You didn't know who owned. So a company could, in a way, in a loophole, they could claim ownership over a piece of your data, and that would mean that you couldn't give it to another company, even though it's your data, which is a bit of a weird one, and it still exists to an extent, but not in the same way. And there were lots of other minor weaknesses. The report's out there. It's on the sources slide. Do have a look. It is quite if you just search up what was wrong with the Data Protection Act 1998, it's just a PDF on Google. It's quite interesting. The Data Protection Act, it updated and replaced the DPA 1998, essentially. It sets out the framework that we've got in the UK. It's pretty simple. It was a lot simpler than the 1998 and other previous laws. And actually, it was a lot more simple than the rest of the EU's laws as well, in terms of data protection. It was amended in 2021 by regulations of us leaving the EU. And there's 3 separate data protection things. There's the general processing regime, which comes under GDPR. And there's 2 separate for law enforcement and intelligence agencies. So you have limited rights as a data subject under these 2. So they can those clauses say they can do what they want, especially this one here. So the intelligence services can basically do whatever they want with your data because you can't go and ask them if they've got data on you because it's national security. Whether you think that's right or not, it probably isn't. But that's the law. And so you could contest that, you could change that, but it's very likely to change. Because you can claim many things about national security and you get away with it. And they created, and I say created loosely because there was already an information commissioner, but they basically recreated the Information Commissioner's Office, or the ICO, as other people know it. Just to briefly go over the UK GDPR, it sets out some key principles. A controller there is someone who manages the data. Processor is the person who quite physically goes through it and processes it. And a data subject is the person whose data it is. It defined what personal data is. It's any data that could identify you directly, or a collection of data that could, together, when you piece them together, they could identify you as well. So what works out of these? And these are from academics that I've spoken to. These are from just people's opinions as well. So there's a better understanding of data protection and your rights as a data subject. And that is true. There's a lot more rights. There's a lot more guidance. We're in this kind of newer age of the internet than we were in 1998. There's a lot more access to information and things like that. There was more transparency as well. So you can do a subject access request now, and you can hound a company and ask for all the data you want on yourself. Often they're a little bit tricky, because you've got to prove that you're yourself. And if you, for example, I don't know, you were like 8 and you signed up to Club Penguin and you want to see all the data they've got on there, it's a bit tricky to prove that you are your 8-year-old self. If, for example, you've lost access to your email account or something like that. But that's an issue with that specific section. There's more concrete rules. They're very, very specific. And they basically say you have to follow your privacy policy if you breach your privacy policy. And then some other bits are not so specific. So if they're saying it's an excessive use of personal data, excessive is not a quantitative term, it's qualitative. So you can't really pick and choose. You have to pick and choose what you want to do with that. But what doesn't work? So I spoke to a number of academics. I also spoke to some MPs as well, and kind of got their opinions on stuff. So one of the things that said was there was a lack of ease of understanding. So it becomes very complex very quickly. And it does. The minute you kind of look at a piece of case law, and it's just like, but this is what it says here. You look at the act itself, it's very, 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 very short. And then you look at what the ICO is saying. It's like, well, how do you get all this from this? There's not much at all. The public very often misunderstand GDPR. I see it all the time. If you're a member of a community Facebook page, that's probably the best place. From back home where I'm from, there's one, and people, if somebody in a local corner shop puts up CCTV of young children, immediately it's GDPR, you can't do this. And actually you can put photos out of people who you think have stolen from your shop. You have to have proof that they've stolen, obviously, because they can contest it. But that's a misunderstanding in a way. Subject access requests, and we'll touch on this when we go to the slides about what MPs believe need to change. But subject access requests are often misused by companies against journalists. So one example is in the wake of the Ukraine war. A huge number of Russian oligarchs in the UK. London's often called Londongrad because of the money laundering and things like that happens in London because of Russian money. And you look at some of the things that MPs were saying, and they can get away with it. They've got parliamentary privilege. But journalists were saying, well, this person's got this house in London. We need to sanction them. And then all of a sudden, they're getting slapped with subject access requests because they're expensive to process. They reckon it's about £500 per request, which is a lot of money if you're a freelance journalist or you're a newspaper and they'll send several of them. So they'll get multiple law firms. And they'll get, 20, 30 multiple law firms. And all of a sudden, that's 15 grand if you've got 30 law firms for one person. And they'll get that same piece of information sent out several times. But once you've built a subject access request, you have to delete it. So you can't then go back and get it again, if that makes sense. So it's one of the things where you've then got to build it again and again and again. In terms of prosecutions, the ICO keeps the fines that it gives out. So the money, despite the money being given to a public agency, to a public authority, and despite the fact that the data is the public's, because it's their individual data, they keep all the money. So that's how the ICO receives no public funding whatsoever. The way they work is they work off the money that they receive in fines. So they're reliant on people breaking data protection, which kind of begs the question of, well, are they the best authority to deal with it then and to give the guidance? Because surely if the way they make money and the way they exist financially is by not prosecuting, but fining, then surely they want people to get fined because otherwise they wouldn't exist and they wouldn't have their jobs. And there's only ever been one prosecution under the DPA, and that was where someone took, 270 people's medical records out of the hospital on purpose to then sell that data on. He did it maliciously. And he did it over 3 years, I think. And they prosecuted him under the 2018. And it was last year, I think late last year, I think he went to jail. And it was a big fine as well. But, that's one prosecution. And you look at the number of data breaches and you go, but they know these happen. They know they're at risk and they don't do anything. You see it in the news. You see that companies have suffered from the same attack twice within the same year, and it's like, well, why haven't you done anything? So you can beg that question as well, and whether you think that's something that needs to change, that's up to you. I spoke to two MPs. I spoke to Nadine Dorries. I spoke to Bob Seeley as well. They were both very nice, and funnily enough, when I was doing my research, and I'll vouch for Bob here. I obviously live in Edinburgh, and he invited me down to the Isle of Wight because he thought I was a constituent, which did make me chuckle. But I spoke to Nadine Dorries about her Data Protection Digital Information Bill when she was Secretary of State for Culture. And essentially, it would make government data less available to individuals. Now, you'll see in a couple of slides that I've had a right pain with the government trying to get information off them that they have to give out. But she wanted to change that so that you couldn't make a freedom of information request to the government. So you can ask them for data that they have to give out anyway, which is a bit of a confusing one. And she also wanted to change rights so that you'd actually get more rights as an individual. So you could actually do selective processing. So if, for example, you are signing up to like Netflix, for example, actually, it's probably a bad example. Like you're signing up to something and it's digital, you don't have to pay for it, right? But you give your email address and then they want your they want your mailing address. They want your, for example, national insurance number. They want your passport number. They don't need all that. but they might stop you from using their service if you don't give them that. So that was what selective processing is. And it'd be things like if you're using Google or YouTube, and you can pick and choose. So you could say to YouTube, I don't want you to recommend me stuff based off this YouTuber that I watch, because that's one piece of data they're collecting about you. So that's, there's a negative to that and there's a positive to that as well. And then Bob Seeley's bill, it's a big long one, because it's only had its first reading, and essentially it would change the way that subject access requests work, because of the way that they're misused against journalists. To briefly touch on the Freedom of Information Act, basically it provides access to information held by public authorities. There's two ways it does this. They're obliged to publish certain information. So any information about their operations that isn't deemed confidential or national security, they have to publish. And then members of the public are also encouraged and entitled to request information from public authorities. Scotland's covered by the Freedom of Information Scotland Act 2002 and the UK one as well. So the Scotland one just sets out some more rights for you, but it builds on the 2001. And it means that there's a couple more public authorities, such as universities, that have to think. So here are my Freedom of Information requests. I sent 340 Freedom of Information requests, and I know what you're thinking, I have too much time on my hands, and I do. 242 of these were accepted. So by accepted, I mean I got the information I wanted, and 98 were rejected. I asked government departments, the UK House of Commons, Scottish universities, and some other public authorities that I haven't actually put in, because I never heard back from them. Because I sent them too late, and I'll receive them after the talk. So I think it's 28 days they have to get back to you. And some of them I received on the last day, which was all the government departments might add. So I received probably about 100 and something emails in one day on my university email account from the government. And I did get an email from the university asking why I've got so many in one day, because they did all come in at a very similar time. And I also was asking for information on various statistics that should be published or not. So it wasn't anything that was majorly serious. But here are some of them. Essentially, there's a ratio there. So the ones that I got and there's some others. So not best friends with Rishi Sunak, to be honest. That's a bit of a disappointing one. You can see that one there is quite crazy. These are all contracts. So they wouldn't give me the money. They wouldn't give me the money sum, because their argument is they shouldn't be giving out this data before it's published. I would disagree with that, because it should be published the minute it's gone through. But they do their own thing. The Home Office were pretty abysmal as well. These guys were absolutely terrible. This was on actually the bills I was asking about. I was asking about who voted on the first reading, who voted on the second reading. They said that it was the House of Commons, who gave me the information, but I actually wanted the consultation papers, and they wouldn't give me them, despite the fact they're meant to have them up before the bill's published. But we won't talk about that. And then there are my other ones as well. That was to do with the salary before I called Dundee Uni out. They wouldn't give me someone's salary, which is fair enough, but again, they should probably have to publish it. And then these were all pieces of information they didn't have. So just to break these down, that's kind of, you can see the chart there. I've sent a good chunk, and the fact that over 25% of those have been rejected is pretty abysmal. And I know my way around FOI laws as well, and I would say most of those that have been rejected, unless they've not got the information, is complete rubbish. And then this is a breakdown here. So the personal information is just that one there. You've got national security. They like to throw that one about. I asked for, I can't even remember what it was I asked for, and they just said national security. I think it might have been... it was this one here. So it was the Home Office just kind of flouted national security at me. And it's like, well, it's not quite. Me asking how many prisoners there are in the UK is not national security. It's just them doing what they want. And then there was confidential contract information, and that they don't hold the information, which is fair enough. If they don't hold it, they don't hold it. And in a way, one of the tricky things you have is that you've actually got the issue with the not holding the information, that who then is meant to hold it, who then holds it. And when you're looking at government, there's all these departments, and they can all hold little bits. If they're not telling you, they just don't tell you. So conclusion-wise, things did improve, and these are just my opinions. The Freedom of Information requests need to be much easier to challenge. You've got to go through a whole internal process, and then you can challenge it at the ICO. But the ICO will only take it if the whole internal process has been done. But half the time, they won't allow you to go with the internal process. So it's fairly tricky to challenge. They should be regulated. They cost a lot of money, and I think that they should have to go through the ICO, for example. And it's a lot trickier than that, but it's just an idea. It needs to be easy to access. They should just have to publish things, and if they don't, they should get in trouble. And the guidance needs to be easier to understand. And to kind of just leave you with one little thing, every time you use and look at the various acts and get frustrated with them, or you're really happy with them, just think they could be better, or they could be far worse. And that's it, really. If anybody's got any questions, and they don't want to ask me now, because I know we're fairly short on time because we started a little bit late, there's my Twitter, and there's my lovely, well-formatted Napier email. If anybody wants to... I mean, I'm discount click, so I can't even read that. But that's probably the best way to reach me. I'm pretty speedy on emails, but if you don't want to write down the long number, that's the easiest way to reach me. And if you want my sources, there they are, and that's it.